estate planning and elder law attorney servicing Southwest Michigan with offices right here in beautiful Portage, Michigan. One of the misconceptions that I often hear in my practice is this one. All my assets are in trust, so Medicaid can't take them. Well, if you think that, let me set you straight. Assets in a trust are countable towards eligibility as long as those assets that you have are accessible. See, Medicaid is for people who are financially destitute. To be eligible for Medicaid, in order for them to pay long-term care in a nursing home, a person can have only very limited assets, generally liquid assets of less than $2,000. Now, there are some exempt assets as well, such as a home, subject to some equity limits, a car of any value, that's exempt, a prepaid funeral contract, again, up to a maximum amount, and cemetery plots for you and your family members. However, any time a trust owns assets, even if those assets would otherwise be exempt, like a house, well, then those assets are considered towards eligibility if a person has any incidence of ownership over those assets. Now, what that means is if a person who is being considered for Medicaid benefits can access the trust assets, even exercise any control over the trust by, for instance, being able to amend the trust as to the beneficiaries or the trustees, then all those assets are considered as being owned by the person. In doing Medicaid planning, you need the assistance of a qualified elder law attorney, someone who specializes in Medicaid planning. Many strategies can be employed to preserve assets for a community spouse or for beneficiaries, but the process is complex and it's complicated. You see, the Medicaid laws are constantly changing. If you have any questions about estate planning, elder law, Medicaid planning, or senior VA benefits, give me a call for a free, no-obligation consultation. You see, I don't charge for advice, and I don't try to sell you products.